night on the CINA 102.3 app at CINAFM.com, on TuneIn, on Smart Speaker, and at 102.3 FM. CINA Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of CINA Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. أسعد الله أوقاتكم بالخير مستمعينا في كل مكان. أهلا بكم في حلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز، وعلى الهواء مباشرة. مكاتب المحامية جومانا كيروز تستقبل كافة القضايا المتعلقة بحوادث السيارات والبيرسونال انجري، immigration، bankruptcy، criminal law، family law، social security، ودائما الاستشارات مجانية. 248 557 3645 248 557 3645. وأذكركم بأن حلقات برنامج يور رايتس أيضا بإمكانكم الاستماع إليها مرة أخرى على الموقع الإلكتروني yourrights.com/radio أو زيارة موقع اليوتيوب والبحث عن قناة جومانا كيروز. وبالتأكيد نستقبل اتصالاتكم اليوم على الهواء في البرنامج على الأرقام 313-769-6666 519-256-123. وموضوع الحلقة سيكون عن الإفلاس مع المحامي مايكل بانكستين، وجومانا راح ترافقنا على الهواء عن طريق السكايب. أكيد نرحب بجومانا، أهلا وسهلا فيك في راديو سينا وفي حلقة جديدة من برنامج يور رايتس.
صباح الخير.
صباح
رامي.
النور، يا أهلا.
هيدي أول مرة بستعمل سكايب من تقريبا 5-6 سنوات.
والله.
عم تسمعوني منيح؟
نسمعك بكل وضوح، وأكيد مايكل أيضا بإمكانه أن يسمعك، ونستقبل أيضا مستمعين بإمكانهم يسمعوك وأنت تسمعيهم. يعني أنه التكنولوجيا ساعدتنا ولو ببعض المسافات أنه نقرب الكل.
عم تتكلم عن التكنولوجيا. بتحب تسألني أنا وين شو عم بتعلم؟
أنت حاليا سمعنا أنت في شيكاغو، صح؟
نعم، أنا بشيكاغو رامي. عم تحكي عن التكنولوجيا. أنا هون لمدة 3 أيام لأتعلم على كل شيء بسموه legal technology. ما بقى فينا نمشي بالطريقة اللي كنا نمشي فيها قبل، لأنه باقي العالم والمجتمع عم يستعمل التكنولوجيا. التكنولوجيا حتى فاتت على المحاماة. إذا بقري لك بعض الهيدلاينز على المحاضرات اللي مدة 3 أيام بدنا نحضرهم you will be shocked. كتير 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 دقيقة حتى رح نتعلم عن استعمال ال artificial intelligence in a law office. شوف لأي درجة.
واو، نعم.
يس من الانترنت للسوشيال ميديا للداتا بريتشز بعتذر artificial intelligence. ما بقدر لك قديش الموضوع متشعب لدرجة انه بيعملوا كل سنة legal technology سيمينار بشيكاغو لمدة 3 أيام.
فأكيد هذا الشيء راح يضيف مكاتبك يعني، وراح يعطيها
طبعا
يعني
that's the whole idea. نعم. حتى هلا رامي صار في شيء اسمه سايبر انشورنس. فنحن هلا عم نفكر اذا لازم نشتري شيء بسموه سايبر انشورنس بحال our clients files لا سمح الله get hacked. هيدي شغله ما عادت مستحيله وما عادت يعني ما بتصير دائما، بتصير كل يوم تقريبا. so yes thank you.
واو. فرحب بك مرة أخرى جومانا، وأكيد معنا المحامي مايكل بانكستين المختص بقضايا الإفلاس أيضا في الاستوديو يسمعك. Michael, you can hear
Good
Joumana,
afternoon,
right?
Michael.
Yes, good afternoon, Joumana. How are you?
I am good. How are you?
I'm well, thank you.
Can you hear me loud and clear? Because I can certainly increase the volume.
I can hear you perfectly, thank you.
Very good. Thank you for being there in person. I am attending via Skype. We are talking about bankruptcy. Attorney Michael Bankstein, you have been extremely busy in the office lately. That is one of the reasons why we haven't been able to have you on the radio. In addition to the new department that we just opened, which is the Social Security and Workmen's Compensation Department, a shout out to Attorney Michael Roth, who is doing a very good job so far, who has been a guest on the radio once and will be again and again. Michael, you have been extremely busy because in great part, I believe our advertised, if I maybe a salesperson for 1 minute, I think that the reason you have been particularly extremely busy lately is because of all these billboards and the advertisement that we have put out there for the attorney fees in a Chapter 7 and in a Chapter 13, as well as what you've been talking about for maybe about 2 or 3 weeks now, the waiver of the, when you file for bankruptcy, as everybody knows, when you file for anything, there is a fee that you pay to the court, and that fee in a bankruptcy proceeding is $335. So you have been sharing with our listeners that in certain circumstances, and it's a financial determination, we are able to make a good case before the court and get the $335 waived. And those are for people who are within the 150% of the federal poverty guidelines. Am I correct?
That's right, Joumana. We've gotten a great response, by the way, on those $575 billboards.
That's true, and also the $335 bankruptcy fee with the court. We are also, getting good result on those. I just want to tell the listeners that this is a fee that you pay to the court when you decide to file for bankruptcy. This is not a fee you pay to any office, and so we would love to see if there is a way you don't have to pay it. And Attorney Michael Bankstein gave us the numbers for those who are listening. If they want to know whether we can get them to save $335, here are the answers. I'm going to list them quickly, and then I'm giving you the floor. If you are, it's all about how much money you bring in, whether you are a household of one, whether you're one person, whether there are 2 of you in the house, whether there are 3 of you, 5 of you, 6 of you, 7 of you, 8 of you. So if you are within 150% of the poverty guideline, you will be a good candidate for making an argument for waiving $335. For example, if you are just one person and your household is 12,400, you bring in 12,490. So if you are, 150 of that, if you bring in $18,735 or less, you will qualify. If you are 2 people, if you bring in $365,000 or less, you will get your, or in all likelihood, your fee waived. If you are a household of 3 people and you make combined $31,995 a year, you will qualify. If you are a family of 4, and a number of our listeners, maybe a family of 4, 5, or 6. If you are a family of 4 and you bring in less than $38,625, you will qualify. If you are a family of 5 and you bring in less than $45,255, you will qualify. And if you are a family of 6, and we'll stop at that, if you bring in less than $51,885, you will qualify. Is that correct?
That's correct, Joumana. That's the most significant factor as to whether or not the court will waive the filing fee, is whether someone's within 150% of the federal poverty guidelines.
Okay, very good. Yesterday I was going over we know that some things we talk about and we repeat. We do that for 2 reasons. Number one, they say that repetition is the mother of learning. If you want to learn something, you repeat it and you repeat it and you repeat it and you repeat it, and it becomes a habit. It becomes a a thought that comes to you without much resistance. And the second reason some of our loyal listeners may hear us repeat the second thing again is because we do not run tapes that have been heard before. Everything is always fresh and new. And so we know that some people who may have listened at one time may not have listened at another time when we shared some valuable information. But again, I mean, I know for myself, and I shared that with Rami one time when we were having a one-on-one radio interview. I told him that, I looked into that personally. I looked into how can I learn something and learn it and be done with it. And that's it. It becomes part of who I am. And all the studies, I mean, the truth is so simple and yet so right on. Repetition. So that's why we do it. We do it because that's how we learn, and we do it because some people who may have missed that information have the opportunity to hear it again.
And that's such a great point, Joumana, because even when I'm meeting with someone in the office, and we've had a couple meetings, we're putting together the bankruptcy, we'll get towards the time when we're going to the hearing that you have to go to in bankruptcy, and they'll say, well, how do we prepare for the hearing? And I tell them, from the first phone call to that consultation to every meeting, I've been asking you some of the very same questions the trustee appointed by the court to do your hearing will be asking you. So when you get to the hearing and you hear the trustee say, have you filed all city, state, and federal income tax returns required for the 4 years prior to filing of the case, you're going to smirk because you get down to that hearing, and that's things that I've asked you 2 or 3 or 4 times to make sure by the time you got down to that hearing, it was just a formality.
Well said. Well said. I want to ask you a couple of questions that we have addressed in the past, and one of them is a repayment plan versus bankruptcy. When people come to consult, and it is a free consultation, of course, with us, the solution is not always bankruptcy. We try to avoid advising them for bankruptcy if there is an alternative way to resolve their financial problems and not file for bankruptcy. Not because bankruptcy is a shameful thing, no. Not because bankruptcy is a bad thing, no. It is in the Constitution. It is a right that is available to give people a second chance, but because bankruptcy, can be a problem in getting credit, in getting good credit, in getting good interest rates, should you, refinance a home, credit cards, and so forth. That's why just that bankruptcy may limit your options in the first year or two after you file bankruptcy, not because it is a shameful thing. But when we meet with our clients, we take a step back. And we're not just looking at bankruptcy. Okay, do you qualify for Chapter 7 or Chapter 11? We also look at another alternative that's a completely different road that is not bankruptcy, and that's called a repayment plan. Tell us about what a repayment plan is. Tell us when does it work and how you go about it.
Well, it's a debt negotiation. It's unlike bankruptcy. It's not court supervised. It's a voluntary negotiation with your creditors to try and reduce.
I do apologize. Is the correct term debt renegotiation, not a repayment plan?
Yeah, it's debt negotiation. Yeah, but I mean, essentially, you're deciding.
My apologies. I like that better. Debt negotiation, because the term is very clear. You are negotiating your debt.
That's
Very
correct.
Good. I like it. Thank you for correcting me. Go ahead.
You're welcome. It's a voluntary negotiation with your creditors, unlike the court supervised process in bankruptcy. And in bankruptcy, you have all your creditors sort of under one roof, and you're either a Chapter 7 bankruptcy where most of the debts are eliminated, or you're a Chapter 13 where you're repaying over some period of time. But in debt negotiation, it's a voluntary negotiation with the creditors. So if you have 10 creditors,
so you're not filing bankruptcy. You're just reaching out. Let's say you have a credit card company and you have an unpaid medical bill at a hospital. These are your 2 creditors. You're reaching out to them. Go ahead.
That's correct. And so if you have 2 creditors, it's a separate negotiation with each one of the creditors, or 5 or 10 or however many creditors that you're trying to negotiate debt with. It's a separate negotiation.
Is the idea that you can negotiate down your debt to something that you can afford and not need to file bankruptcy? Is the idea that if you have a $5,000 emergency room bill, you can maybe negotiate down to $3,000, or maybe enter into a payment plan?
That's correct. So in the example of a $5,000 bill to the hospital, you may typically you can get the debt down to about maybe 40 to 45 cents on the dollar. So if you have a $5,000 debt, and let's say they write down 60% of it, then you're only having to come up with $2,000.
Correct. And then what do you do after that? Walk us through a mock scenario. Someone comes to you and they have a credit card, large balance, and they have a large medical bill. How do you go about beginning and going through the debt negotiation?
Well, the first thing I do is I put a budget together with them to see, what all of their household expenses are, what all their household income is. I compare the two, see how much money is left over at the end of the month. Because the idea in a debt negotiation is you stop paying on, the credit card, on the medical bill, and then during the negotiation process, you're holding on to that money that you would normally be spending. So that it's sort of pooling up. You hold on to that money so that when you get to the end of the settlement and a settlement is reached, you're able to fund that settlement in a lump sum payment.
So let me ask you a question. If I came to you today and I have a large medical bill and a large credit card, you are going to begin by reaching out, picking the phone and calling the legal department in the hospital and the credit card company and telling them, listen, I have a client who wants to file for bankruptcy. If she or he files for bankruptcy, good luck to you getting any penny, because what he or she owes you will be discharged, meaning will be wiped out in bankruptcy. Or you can be reasonable with me and you can agree to enter into a payment plan with my client for a reduced amount, correct?
That's right. I mean, that's a major stick in the negotiations for people who owe money is that, if we can't work this out voluntarily with debt negotiation, we could file a bankruptcy and you may get nothing.
So you always kind of say that, whether you imply it or whether you come out and say it, or maybe they understand that when you call them and say, I am calling on behalf of a client who wants to negotiate down that debt, you'd better work with me, otherwise he'll be filing for bankruptcy and you will get nothing. How long do the negotiations, because you just mentioned while your lawyer is negotiating those bills on your behalf, you do not pay. And you save that money so that at the end of the negotiation you can pay it up. How long does it take from the time you pick up the phone, call a hospital or a credit card, to the time you come into an agreement with these entities?
I've seen it as short as 6 months, but it's more typically can be 12 to 18 month process.
Why does it take this long?
Well, it's partially a function of what someone's able to do. So if you have you probably don't have $2,000 in your back pocket if you're facing some financial problems. So somebody may have $200, at the end of the month. So it may take several months of them holding on to that because the creditors do expect a payment in a lump sum shortly after settlement. So it's partially that. Also, the longer they go without getting their money, the more likely they are going to cut a deal. So, if you've been paying every month and then all of a sudden you stop and then you call them up and you say, I want to work this out. Well, they've been getting their money. If 2 months go by, 3 months go by, 6 months go by, and they haven't gotten anything, that can help in terms of what you wind up having to pay.
Attorney Michael Bankstein is the person who is attempting to negotiate a debt down. Say a client of yours who came to you and you're negotiating with the hospital or the credit card company. Are they at risk of being sent to collection?
That is possible. That's one major difference between debt negotiation and bankruptcy is that whatever chapter of bankruptcy that you file, as soon as you file a bankruptcy, there's something called an automatic stay that goes into effect. That means that your creditors can't engage in any activities for purposes of collecting a debt. They can't call you, they can't write you, they can't sue you, they can't garnish you. Everything has to stop. There's no automatic stay with debt negotiation, so they can still call you and write you. Somebody may sue you, so it is a little bit more of a bumpy ride.
So that's one of the, let's say, risks of engaging in debt negotiation is that while you're doing that, you may be sent to collection. And is there a way, as a lawyer, you can tell these creditors to promise not to send your client to collection?
I mean, you can ask them, but you can't. The whole thing about a debt negotiation is it's a voluntary process. You can't make them do anything. So if they want to send someone to collections, I mean, you can ask them not to. They may or may not still send it to collections.
Okay. And have you seen it where you've represented clients in debt negotiations and during dependency of the debt negotiation, your client informed you that have been sent to collection?
Yes. That's and I've seen people get.
So that's one of the risks.
Yes, absolutely, and I've seen people get sued for the money also in the middle of the debt negotiation process.
Right, because it does not stop the process. Whereas the minute you file bankruptcy, so there are advantages and disadvantages both ways. Debt negotiation keeps you out of bankruptcy, keeps your credit score better, entitles you to continue to look for competitive interest rates and so forth, whereas bankruptcy, the first couple of years after bankruptcy are a bit tough. They're less tough than people think, but they're a little bit tough, and then it stays on your credit report for 10 years and so forth. When you file for bankruptcy, anything you owe anybody, there is a stay, meaning a freeze, meaning if you owe me money, Michael, and you filed for bankruptcy, then I cannot do anything, because as long as, and that's a very important point that I think we need to make, as long as I am listed on your schedule, because when you go to file for bankruptcy, you have to list all the creditors to whom you owe money, correct?
That's right, Joumana.
So if you owe me money, you have to list me on your schedule, correct?
That's right. You have to list everyone you owe money to and all your debts and everything that you own.
So with the fact that you listed me as a creditor on the schedule, will that entitle me to obtain a copy of what's going on? How else will I know that you have filed for bankruptcy? Will there be like a proof of claim or anything like that? How will I, as a creditor, know that the person to whom I have given money has filed for bankruptcy?
The bankruptcy court will mail you notice of the bankruptcy filing and also let you know when the hearing is going to be.
What if somebody omits and makes an error and forgets to add a certain creditor on the schedule? Correct me if I'm wrong. That means nothing prevents that creditor, say it's me, and you forgot to put me on your schedule, nothing prevents me from suing you, correct?
Right. If they've never got notice of the bankruptcy, then the automatic stay isn't effective against them because they haven't been notified.
But what if a creditor who has not been listed files a lawsuit and comes to find out that the person against whom they filed a lawsuit is in bankruptcy? Is that enough to ward them off, given that they're not listed on the schedule?
Yes, if the creditor becomes aware that you're in bankruptcy, then what's going to happen is that creditor, they don't want to be in violation of federal law because, if for whatever reason they weren't notified, but now they know that you're in bankruptcy, they have to send a proposed order over to the court where they're suing you. It's called a order for administrative closing due to bankruptcy stay. So that local, state court has to stop what they're doing and the creditor has to stop what they're doing when they become aware of it.
Okay, so there are legal consequences to any creditor who approaches someone who filed for bankruptcy once they are put on notice, even if they were not listed in the schedule. Once they are aware that the debtor is in bankruptcy, they must stop. Otherwise, they will face serious legal consequences, including being held in contempt of court.
That's correct. Although I've got to say most creditors, the vast majority of creditors, they don't want to fall afoul of federal law. And as soon as they become aware that you're in bankruptcy, they back right off.
If you filed for bankruptcy and you did not list me as your creditor, what happens to the debt you owe me?
Well, we've got case law in this district that's binding that says that if you were an unsecured creditor, and I'll talk a little bit more about secured versus unsecured creditors in a moment, but if you're an unsecured creditor, and
an individual is generally an unsecured creditor.
Yeah, you can think of credit cards, medical bills, deficiencies in automobile repossessions, that sort of thing.
Okay.
As opposed to like a mortgage or a car note or something like that. But if you were a general unsecured creditor and you didn't receive notice of the bankruptcy, but had you received notice of the bankruptcy, you would not have had a basis to object to discharge, then that discharge order is still good against you.
Oof. Okay, I understand. So even if you forgot to list me as a creditor, and had it been that I was listed, my loan to you would have been wiped out, then my loan to you is going to be wiped out, although I was not on the schedule.
Right. It's kind of an old-fashioned term, but you've heard the Scrivener's error sort of thing. So if it just didn't make it in there, it's like, okay, you didn't get notice of the bankruptcy, but so what? Had you had notice of the bankruptcy, you couldn't have done anything anyway.
It would not have made any difference if your debtor had listed you on the schedule.
Right, and that's absolutely not a license for keeping 10 or 15 people off the schedules. But if you miss one, but it's important that if they did have a basis to object, then that discharge order wouldn't be good against them.
Okay, I would like to remind the listeners that we are talking all matters bankruptcy today. We have another 30 minutes remaining. For anyone who would like to call Attorney Michael Bengstein and ask or comment about any bankruptcy or debt negotiation matter, the numbers, Rami, are
313 769-6666 from Windsor 519-256-1023.
Thank you very much. رامي آخر نقطة كان عم بيقولها بفتكر من المستحسن انه نترجمها للعربي بطريقه سريعه. وقت الانسان بيقدم على افلاسه بيكتب سكادجول، يعني بيعطي لائحه عن كل الاشخاص وكل الشركات اللي بدهم منه مصاري، لانه الفكره انه وقت بتقدم على افلاسك عم بتقلها للمحكمه عندي 15 شخص وشركه او 20 شخص وشركه بدهم مني مصاري بدي اقدم افلاسهم. في احتمال اوقات الانسان اللي عم بيقدم على الافلاس ينسى شخص أو ينسى مؤسسة بدها منه مصاري. سؤالي كان للمحامي مايكل بينغستين إنه إذا إنسان نسي يضيف شخص أو شركة بقلب السكادجول، معناتها البانكربسي ما بتطبق. يعني إذا أنا مثلا دينته للمحامي مايكل بينغستين $1000 وهو قدم على إفلاسه ونسي يحط باللائحة اللي عطيها للمحكمة اللي بيسموها سكادجول بالإنجليزي، إذا نسي، وهلأ بناخد دكول الرامي أول ما خلص الفكرة، إذا نسي يحطني، القانون بيقول مع انه انا مني جزء من البانكربسي، بس لو كنت جزء من البانكربسي كان كمان الدين تبعي رح ينمحى. يعني ما أثرت، ما كان إلا تأثير انه هو نسي يحطني، الا اذا كنت شيء هو secured creditor، يعني مثل بنك، مثل كار كومباني، هدول secured. شغلي شوية معقدة، بس اجمالا اذا كنت انت unsecured creditor حتى لو نسي الشخص اللي قدم إفلاسه يكتبك على اللائحة السكادجول، النتيجة هي ذاتها، فكمان أنت الدين تبعك بينمحى. ورامي إذا بتسمح بناخد أول اتصال.
أكيد ناخد اتصال معنا على الهواء. له مساء الخير.
مساء الخير.
يا أهلا.
يا أهلا وسهلا. ومع مين عم نحكي؟
This is نادم شعيا.
أهلا نادم.
نادم شعيا؟
Yes, ma'am.
يا أهلا وسهلا أستاذ شعيا.
Yes, I would like to ask a question about the bankruptcy.
تفضل.
Mr. Rami?
تفضل نادم.
Okay, I owe about close to $400,000 in my mortgage and second mortgage I have in my house. And I need to file a bankruptcy, but I need to file a Chapter 7. Is it possible I can qualify for it?
So the question, Attorney Michael Bankstein, does he qualify for Chapter 7, or will he be a Chapter 13? He does owe $400,000 on his home mortgage.
It depends on how much the property is worth, because it's not so much what you owe on your real estate. And I'm assuming that's your residence. If it's your residence, and there's a certain amount of equity you can protect when you're in a Chapter 7 bankruptcy. So there's two sets of exemptions. There's federal exemptions and Michigan exemptions. The federal exemption is $23,675. And the Michigan exemption, if you're under the age of 65, is $37,500. So, for example, if the property was worth $420,000 and you owed $40,000 on it, the equity is $20,000. You can protect that using the federal exemption. And it's important to note that if there's someone else on the deed with you, for example, if you're married and your spouse is not filing, we're looking at your undivided 1/2 interest in the equity.
So, Michael, let me interrupt and just break that down a little bit. Mr. Shaya, if your house were to be appraised today, what do you think it will go for, the appraisal?
Well, my house is worth right now, they praise it, sometimes you praise it on the internet, it's showing $395,000.
Okay, so it's appraising for around the money you owe. Is your wife with you on the title, or is the title only in your name?
The title is under my wife's name, but the loan is under my name.
Okay, so the house is titled to his wife. The debt is in his name. Michael?
Yes. What I would say in that case is the house is you owe $400,000 on it. The house is worth about $395,000, so it's actually underwater by about $5,000. So definitely you can protect the house because you don't have any equity to protect.
You cannot protect the house.
No, that's the opposite. That's the complete opposite of what I'm saying. If it's worth $395,000, but you owe $400,000 on it, you've got negative $5,000 in equity. So you don't have any equity to protect. So it wouldn't be in danger on that basis. So
does he qualify for Chapter 7 or Chapter 13?
Well, there's four
we need
basic.
to ask him about his income, correct?
Exactly. There's four basic things that you need to qualify for a Chapter 7 bankruptcy. You can think of it like the four legs on a table that hold up a tabletop.
May I interrupt for a minute?
Sure.
What is the benefit of the Chapter 7 versus Chapter 13 as far as a home?
The benefit of a Chapter 7 is that, if you're keeping the home, you wouldn't be able to get rid of the mortgage in a Chapter 7, but keep the house. You have to decide that you're going to continue to make the payments moving forward. But if you have any other kind of debts, credit cards, medical bills, what have you, you wouldn't have to pay any of that, but you could keep your house. And it's a much shorter process, too. You're from the filing of the case to the closing of the case and getting your discharge is about 6 months, whereas a Chapter...
Because Mr. Shaya began by asking, can I file Chapter 7?
Yes, there's four main factors that go into whether or not you can file. Based on the equity, that would not be a roadblock to being a Chapter 7.
So he can. Yes, he can.
Yes, if he also qualified for the other three main things.
And what are they?
For example, if you file a Chapter 7 bankruptcy before, you have to wait 8 years until the filing of the previous case, because you can only file a Chapter 7 every 8 years. Have you filed for bankruptcy before?
No, that's my first time.
Okay, so you're already halfway there because we know there's no equity to protect and you haven't filed for bankruptcy before. Then you look at the household income, you subtract the out-of-pocket expenses. If you have little or no ability to repay your debts over time, that's another strong indication of a Chapter 7. So if somebody has, $50 or $75 left at the end of the month when you subtract all your expenses, that's a good indication of a Chapter 7. Whereas if you have $500 left at the end of the month, that's way too much to be a Chapter 7.
Yes. Is it possible I can get your phone number? That way I can have a meeting with you?
Absolutely. Do you have a pen? I have the number right here.
Yeah. Give me your phone number, Mr. Rami.
Sure.
I have it too. It's 248
248
557
557
3645.
3645. That's the
36,
office phone
3645.
3645. I got that.
Now.
What's the other number?
I'm sorry?
What's the other number you have?
I have 248-557-3645 is our main line.
Okay.
That's a good number to call to get set up for a consultation. I could meet with you and go over your situation for free.
Yeah, great. One more question I want to ask.
Mm-hmm. Go ahead, please.
What I just did recently, I transferred the title under my wife's name. That the title for the house, like 3 months ago. As it will be affect my Chapter 7 or no?
Did it used to be just in your name only?
No, it was my name and her name. But what I actually was my name only, and I transferred the title under her name.
Okay,
is that okay with me to qualify for Chapter 7 or no?
One of the things that the court looks at is whether or not you've made any transfer of property within the last 6 years. It's not a problem if real estate was transferred for value.
For value, for the same value.
But if you
not as a gift.
If you
I did it as a gift. But even my wife, she's gonna come. She's gonna with me on the bankruptcy of Chapter 7.
Okay, I mean, that shouldn't be a problem if she's filing too, although it may be a good idea for her to deed it back into your name, basically putting it back like it was before the transfer, before you file for bankruptcy.
And one more question I ask. I have 2 mortgages on my property. First mortgage is a Wells Fargo, and second mortgage, it's DFCU Credit Union. The DFCU Credit Union, it's $84,000.
That's a second in priority.
And the Wells Fargo, it's about $300 and some thousand. So, what's a good advice? The other one, the DFCU Credit Union, it's like a kind of line of credit of $84,000. Can I put that second loan, its line of a credit of $84,000 at the bankruptcy or no?
If the line of credit, if it's secured, if it's tied into the house, and the way to know that is whether or not that's been filed with the Register of Deeds office. If it's actually tied into the house, then it's a secured debt, and generally secured debt is not dischargeable in a Chapter 7. So you couldn't, if it's tied into the house, you can't dump the debt on the house and keep the house. There is something in Chapter 13's called lien stripping, when you have a second mortgage on your house, but that only works if you're underwater on the first mortgage. So you've got a Wells Fargo loan of $316,000. If the house was only worth $275,000 or $300,000, that means that there's not even enough equity for the first mortgage. If there's not even $1 of equity that spills over into the second mortgage, in a Chapter 13, you can file what's known as, you can strip out that second lien, but that's not available in a Chapter 7 in our district.
Okay, very good. No problem.
Thank you, Mr. Shaya, and do not hesitate to call Michael. He will go over the analysis very closely with you, and he will advise you. Mr. Shaya brought up a very good point, or rather you, Michael, by talking about whether or not that secured mortgage will be dischargeable or not. I have a list here that you have compiled, Attorney Michael Bankstein, about debts that you can discharge and debts that you cannot discharge. Here are some of the debts that, yes, you can if you file for bankruptcy discharge. When we say discharge, bankruptcy discharge, meaning wiped out, meaning that the person who owes money no longer is liable, responsible to anybody. So a bankruptcy discharge is something that really releases the debtor from the liability. Discharge, wiped out, gone, wiped clean. So here are the kind of debts, and correct me if I'm wrong, Michael. I'd better not be wrong because this is your list of debts that can be discharged. Credit card debts, yes, they can be discharged. Personal loans between individuals can be discharged. Payday loans, medical bills, deficiencies on automobile repossessions, deficiencies on foreclosures, old utility bills, And civil lawsuits, civil judgments are example of those kinds of debts that will be wiped out, eliminated if you file bankruptcy. There are debts that you cannot discharge in bankruptcy. Even if you file bankruptcy, you are still stuck with those. Some of them are obvious to everybody. Child support. You cannot file for bankruptcy and say, I don't owe my children any child support or my ex any spousal support. Criminal restitution is also not dischargeable in bankruptcy. Intentional torts, correct, Michael?
That's
Intentional
correct.
torts. I was involved in an arbitration not very long ago that was a civil dispute, and it was, over the sale of land. And what the person who bought the land is alleging the person who managed the land has done wrong. And the judge's order, the arbitrator's order, we asked that the arbitrator's order include language that, and there were the facts were there to support that, of course, but we specifically asked the arbitrator, who happens to be a retired judge, to include in his arbitration award, in his arbitration order, language to the effect that this was an intentional tort, because we did not want the person to go and laugh at us and file for bankruptcy. If we had not included that language, that that it is an intentional tort or a criminal, then he can file for bankruptcy, and everything we did would have been all gone in vain. So I wanted to bring that up. Student loans, it depends, but those that are government-backed are generally not discharged in bankruptcy. There is a nuance to that, correct?
That's correct. Student loans are generally not dischargeable. I've never seen any government loans get dischargeable. There is a way outside of bankruptcy if someone is, very severely disabled, and there's other conditions that sometimes it can get discharged by the U.S. Department of Education. But within bankruptcy itself, they're generally...
So what we should tell our listeners is that generally speaking, student loans are not dischargeable, but you need to analyze with a competent bankruptcy attorney that specific student loan, because it may, or parts of it may be dischargeable in bankruptcy.
Yeah, one thing I've noticed is I have seen a few cases where not the government loans, but the private loans sometimes get charged off by the holder of the student loans. I mean, it's not all the time. It's not even the majority of cases, but I have seen several cases here and there where I don't want to oversell that, but sometimes the private loans get charged off.
Similarly, Attorney Michael Bankstein, and by the way, we have 10 minutes remaining. We can certainly take a call. We thank Mr. Shaya for calling and contributing to this discussion. The number to call is 313-769-6666 and 519-256-1023. We also often get asked, Attorney Michael Bankstein, about income tax, whether it's dischargeable, tax returns, whether they are dischargeable. And the answer here depends, correct?
That's right. If the tax returns, which gave rise to the income tax debt, were filed timely, and the tax year which the income tax debt pertains to was at least 3 tax years ago, generally it is dischargeable.
So you look at the last 3 years and whether you have filed your taxes, your tax returns timely.
That's right. And there are, if for whatever reason the IRS files a tax lien, well, as soon as there's a lien, it becomes secured, not unsecured. So there may be circumstances in which it's not dischargeable if it's secured rather than unsecured. But if the IRS hasn't put a lien on it and you timely filed the tax returns and it was 3 tax years ago or greater, it's generally dischargeable in bankruptcy.
Okay, and for an individual to timely file your tax returns is April 15. If you request an extension, although granted, for the purposes of this income tax and whether it's dischargeable or not, it's not considered timely. Am I correct or am I wrong?
Well, I mean, if you've got an extension, that may not be an issue. Much more commonly, what I see is someone just hasn't filed their tax returns for 2 or 3 years, and then that's clearly not timely filed.
Okay. I was in the process not too long ago of looking at my life insurance and determining whether I need to supplement my life insurance. And I was dealing with the insurance agent for the life insurance company. And the thought popped in my head, what if that company files for bankruptcy after my death? What if you deal with a car insurance company and it files bankruptcy? Do they list you as a creditor, and where will you get paid from? So let's say you bought life insurance, or let's say you are doing business with a company and the company files for bankruptcy. Sometimes very big companies, very large companies file for bankruptcy, and sometimes smaller companies of under 50 employees file for bankruptcy. What happens to me and you if we are creditors for whatever reason of that company?
Well, if you are a creditor, you'll get notice of the bankruptcy, and you definitely would want to seek the advice of an attorney, because there are deadlines depending on what chapter was filed. If it's a life insurance company, it's likely to be a Chapter 11. There's deadlines. There's claims that have to get filed. You definitely want to run, not walk, to a bankruptcy attorney's office to preserve your rights.
By filling out what's called a proof of claim. But my question becomes, that company is filing for bankruptcy. Who is going to pay me?
I haven't personally encountered that, but I can do a little research on that.
Well, we know that if it is a bank, it is covered by the FDIC.
That's correct.
Right. And by the way, Attorney Michael Bankstein, weren't you a banker for many, many years?
Well, for a very short time, I did some loss mitigation for J.P. Morgan Chase Bank. We did
for a short time. My apologies. I thought for a long time.
For about a year, I wanted to get a taste of that to sort of supplement my bankruptcy knowledge. So we definitely did some deeds in lieu of foreclosure, short sales, settlement and release of liens. I also did some mortgage subordinations in connection with refinancing. Okay. That really helps to kind of have an idea of what the person on the other side of the table is thinking. That definitely helps when you're making a strategy and putting a plan of action together for bankruptcy.
I don't know how much, whether the time remaining will be sufficient to go into this discussion at length, but let's give it a try. We have about 7 minutes remaining. Someone is thinking of filing for bankruptcy, owes money to a family member, singles out the family member, pays off the debt, and then files for bankruptcy.
That's what's known as a payment to an insider. It's not what you owe, it's what you've paid within the year before the case was filed. I've many times encountered that in a consultation. People know not to do something like that moving forward, but they didn't necessarily know to do that, 6 months ago before they picked up the phone and called the bankruptcy office. There are ways to fix it. So if you owe, if you paid Cousin Sam back $500 6 months ago, one of the things you could do is you could get the $500 back from Cousin Sam, park it in your bank account. The trustee can't touch that money. Basically put it back like it was, and then file for bankruptcy. And again, if you're in a Chapter 7 bankruptcy and you're in and out in about 6 months, what you do when you're no longer under the jurisdiction of the bankruptcy court is between you and Cousin Sam. Another way to fix it is, if you can't get the money back from Cousin Sam, is the look-back period is 1 year. So you could wait a year and a day to file the bankruptcy, then the transfer is long enough ago that it doesn't matter. For a payment to an insider, that's someone to whom you're related by blood or marriage. The third thing is, if you can't wait a year and a day, and maybe you've got something pushing you, like a garnishment or a possible repo or something like that, If you can't wait a year and a day and you can't get the money back and put it back like it was, just understand that you may have to pay that $500 to the trustee. Now, the trustee knows you don't have $500 in your back pocket, but you may have to pay the trustee back over a period of time, maybe 6 months to a year.
Okay. That's different from conveying. Paying someone, they look back a year. However, conveying something, they look back 6 years.
Yeah, there's 3 issues that are separate but very interrelated to each other. So you have transfers of property, you have payments to insiders, and you have preferential payments. In a nutshell, the difference between the 3 is a preferential payment is if you're preferring one creditor over another. So you pay $800 to Visa so that they have a zero balance because the thinking goes, well, they've got a zero balance, now they're not a creditor, so I don't have to list them on the bankruptcy. But if you've paid them $600 or more over the 3 months before the case is filed, then you've made a preference payment, and the court, the bankruptcy trustee, appointed by the court to administer your case, can go in there and undo that preferential payment. The transfer is 6-year look-back period for transfers of property. Typically, real estate, vehicles, that sort of thing. And payments to insiders is a year for someone to whom you're related by blood or marriage.
Understood. In fact, I have heard, or I have read rather, that if you pay off a credit card because you want to keep it after bankruptcy, if you pay it off and then file for bankruptcy, the credit card company is going to cancel your card.
That's correct. They'll take your money and then close it anyway when you've filed.
How will they know if they are not listed as a creditor because you've paid them off?
Well, because the fact that you filed for bankruptcy appears on your credit report for 7 to 10 years, depending on the credit reporting agency. And again, your credit does start to repair about 18 months out from the filing. Over time, it does repair. But the fact that you filed is on your credit report, and credit card companies pretty frequently pull the credit reports of their customers, and they would see that a bankruptcy had been filed even though you hadn't filed it on them, and they would likely close the card. So that $700 is better left in your bank account to help you rebuild your capital cushion.
Attorney Michael Bankstein, listening to you analyze and answer the questions, this time like previous times, the same thought occurs to me that in bankruptcy law, it is better that you consult with someone who knows before you even make a decision. For example, Mr. Shaya, who decided to deed the house from, I believe, himself and his wife, just to his wife, that was a futile thing that didn't help him at all, and now he wants to deed it back. The person who pays a relative, the person who pays a credit card, thinking that they can help the relative or keep the credit card. There are consequences and there are legal ramifications. You talked about the preference payments and the conveyance of property and so forth. They look back 6 years. In fact, in a previous show, you talked about a father who may have gifted a home to his son, and it was done under 6 years from when he filed for bankruptcy. They're going to attribute a dollar amount to that, although the father was sincere in gifting his son the home, and it was not in anticipation of bankruptcy. It may have been 5.5 years ago, but the law says that they look back 6 years. And if he gave it to his son not for the market value of that house, such as a gift, then it's one of those assets that's gonna go on his bankruptcy, correct?
That's absolutely right, Joumana. I'm glad you brought that story up, because that's an important point to emphasize, is that there doesn't need to be a fraudulent intent. Even if there's no fraudulent intent, if it was transferred for less than market value, that still falls within the fraudulent transfer statute.
Thank you very much. Attorney Michael Bankstein, it's always a pleasure to have you. I learn a lot from you, and I hope the listeners as well. Those who want to listen to this again can wait a couple of days, and they will have it under the Joumana Kayrouz YouTube channel. They will also be able to listen to it on our website, yourrights.radio. Rami, thank you very much.
شكرا
You've
لك.
made this Skype wonderful and easy. I'm going to use it now all the time, Rami. You're not going to see me anymore.
المشكلة هذه.
Thank you so much, Joumana. Thank you, Rami.
We'll see you إن شاء الله قريبا في الاستوديو ونتمنى لك إنه ترجع بالسلام إن شاء الله وشكرا جزيلا على وقتك.
ورامي إذا بتسمح بذكر المستمعين إنه المحامي سام سيف رح يغطي بكرة عني. رح نحكي كمان هجرة بين الساعة 3 والساعة 4 بعد
إن شاء الله. تحياتنا لك جمانة. شكرا لكل مستمعين على حسن المتابعة ودمتم في رعاية الله وحفظه.